Welcome to FAQ, where your patient questions are answered by leading experts in medicine and wellness. And now, here's your host, Hailey Hough.
Hi, I'm Hailey Hough, and welcome to FAQ. Today our question comes from Kristen, a student in Cleveland, Ohio. Kristen asks, what are my rights as a college student to protect confidential medical information from being released to my parents and also to potential employers, especially when I'm applying for internships and/or employment? To answer your question, Kristen, we turn to our guest expert, Dr. Tondra Moore. Dr. Tondra L. Moore serves as the Executive Director for Health Services in the Division for Student Affairs at Prairie View A&M University in Prairie View, Texas. In this role, she oversees operations of the Owens Franklin Health Center, Student Counseling Center, Office of Disability Services, and Hilltop Reserve, an emergency resource center. Additionally, she serves as the health administrator for the Owens Franklin Health Center, which provides ambulatory care for the campus as well as the local community of Prairie View. Throughout the COVID-19 pandemic, she has served as the lead public health official and incident commander for the university. Prior to joining Prairie View, Dr. Moore served in numerous faculty and academic leadership positions and is also a leading researcher in the areas of health disparities in minority populations, healthcare policy analyst, and the lack of diversity in the pipeline to leadership in healthcare organizations. Dr. Moore earned a Juris Doctorate from Cumberland School of Law at Samford University, Doctorate in Administration, Health Services, and Master of Public Health from the University of Alabama at Birmingham, and Bachelor of Science in Chemistry from Alabama State University. Welcome, Dr. Moore.
Thank you.
So please explain the rights of a college student when it comes to their college medical record. What are the rights and confidentiality?
So I think it's important to start off with just a brief overview of some of the guideposts for privacy when it comes to medical records for college students. So the Family Educational Rights and Privacy Act, which is better known as FERPA, is a federal law that protects the privacy of student education records. Now, FERPA affords parents certain rights with respect to their children's education records, but these rights transfer when the student reaches the age of 18 or attends a post-secondary institution at any age. Now, many college medical records are actually covered under FERPA as treatment or educational records. When we interact with the healthcare system, we typically hear of HIPAA. Now, HIPAA is the Health Insurance Portability and Accountability Act of 1996, and its privacy rule was enacted to improve the efficiency and effectiveness for electronic care transactions and to protect the privacy and security of individually identifiable health information. Now, HIPAA only actually applies if the entity providing the care is considered a covered entity. Now, I wanted to mention both of these because while most are familiar with the terms when it comes to general privacy, they aren't familiar with the intricate requirements for both one or more to actually apply. But I think the most important thing for students to note is that each institution has a responsibility to make a case-by-case analysis to determine whether or not disclosure of treatment or medical records without consent meets either FERPA or HIPAA requirements. So the general guide is to understand that even with these rules, there are some circumstances and exceptions that do allow disclosure of both types of information to parents or others without consent. So let me just give an example. So for an example, if there is a threat of imminent harm to self or others, then there is a need to inform a caregiver. Let's say if a student has some type of severe or incapacitating injury, then in that circumstance, we actually would have to go in and notify those parents without the consent. But it has to be noted that these exceptions generally do not apply to employers. And so it would take specific consent from the student to allow the disclosure to an employer, or that special circumstance that there is the possible threat of harm. So let's say that a student was not happy with an interview. We all know sometimes the interviews don't go well, but they're in a therapy session and they storm out of this session and they are actually making a credible threat about the intent to cause harm to someone at that potential employer's office, then that could trigger the duty to warn. But this is a very rare case and very rare circumstance. And so it has to be noted that in college medicine, most of the practitioners, we value student confidentiality so much so that we often upset parents, because parents frequently do contact us and ask us because there is the misconception that because I pay for the service, I have rights to the information regarding the service. And we have to simply inform the parents that the student does have a right to the privacy of their medical records or their health records, and that it does require us to have consent. And oftentimes it's signed or written consent from that student to the student health clinic or entity to actually disclose the information. Once we actually explain the process to parents, explain to them what's required, they understand. But I do think that we may be seeing this particular question because of, one, the increase in parental involvement in the care, but also because I think COVID has created a very interesting situation for individuals, and they're very curious about what information regarding my particular healthcare can be provided without my knowledge or without my consent. And while during this pandemic, there has been the expansion of some public health reporting requirements, I think that students should still feel confident in understanding that college medical providers still operate with their confidentiality and privacy as one of the hallmarks of our response protocols. But I do advise all college students to contact their specific student healthcare providers and ask for the school-specific rules. And that's going to be very important, because I do know this question came from Ohio. So even though the school will have very specific rules, those rules still have to pertain to the individual state laws. So it's very important for students to know what rules apply at their institution, because that institution would have considered all of the federal as well as the state rules required.
Well, that was an excellent response. Thank you so much. And just to follow up on some questions, you did mention that you do advise students to contact their specific school to get their rules. And I just was kind of curious, is it different between schools that are maybe in the same state? Are they still going to vary their rules on, their confidentiality? Or are they all going to look pretty similar regarding what state they're under because of the health rules of that state?
So Hailey, that's an actually very good question, because the rules can vary from school to school within a state. Because when I spoke earlier, I spoke about the rules that apply for, let's say, HIPAA to actually be, for that individual, that organization to be considered a HIPAA covered entity. So that means that they would be, let's say, for example, a larger school that would possibly have contracts with healthcare insurance companies. And so they would be transmitting this information regarding that student's care for billing purposes electronically to that insurance company. That particular school then would fall under HIPAA. Under HIPAA. But if there was, say, a smaller school that had none of these contracts, the students paid a student health fee only and then paid all other expenses out of pocket, those rules would then fall specifically under FERPA, and that school would not be considered a HIPAA covered entity. So therefore, there would be a little bit of difference in how the privacy rules apply. The general concept of confidentiality and privacy would be in place, but there would be different exceptions or exemptions based on the different rule that apply. And also, there is a requirement under FERPA that is linked to the way in which the entity gets funded, whether or not it's a federally there's any federal funding that comes in. So there may be a private school that's not getting any federal funding, and it's not transmitting any information. And so then they're going to still have a little bit of difference in what rules apply to them. But what we should know is that regardless of what the law is, one of the basic tenets in healthcare is that we protect the privacy and confidentiality of our patients that we care for. So the school in general, regardless of which law it falls under, will have that tenet in place in some form or fashion, but the specific requirements for that school would vary based upon how it is identified.
Okay, gotcha. That definitely clears it up. That's very interesting, though. I did not know that it was, very different between a few schools. It's definitely something that I feel like students would need to know to follow up on for sure. So kind of going back to the parent side of things and the confidentiality as it pertains to the parents, are there any other instances rather than just, something that's a self-threat or anything like that, any broad section where you would have to inform the parents other than, individual threat?
So they're not broad sections where we have to inform, but there are some general things. So I spoke earlier about how FERPA, the rights under FERPA are with the parent until the student reaches a certain age or they attend a post-secondary institution. But if that student, let's say, was to pass away, then those rights would revert back to the parent. The parent would then have access to that information. So it's important to know there are some things of that nature where information can be shared after the fact. There are instances where, like I said, if the parent is a caregiver, or if the student has designated that parent as their personal representative, then their information can be shared under HIPAA and FERPA. There's general information, typically what we talk about in directories. So if I'm in a hospital room, in a certain hospital room, the number to that room, that's considered directory information. And so that information can be shared. So those are just some general areas where information can be shared. And again, we have requirements. Every healthcare entity has legal requirements to report out certain information. And that's where I was speaking about how I think COVID has come in and really heightened people's awareness, because we still have that public health reporting requirement. But that public health reporting requirement doesn't mean we report to the parents. It means we report to the state agencies and things of that nature. But there are a few exceptions when it comes to who we have to contact and when we have to contact them. Now, I will tell you that one of the things that is very common for us is to have very candid discussions with our students, because there are times when we are treating patients and they don't necessarily want their family members to be aware, but it is at that level where we truly believe that there is the need to call in a family member for assistance. And during that time, what we typically do is have some very personal counseling with the student to explain to them why we think this is that point where they need to call someone in. And we typically are there with them to help them through that process, because there are times when you do need others to come in, especially if we have to transport students off to the hospital and things of that nature. We want them to know that, your parent needs to know. So you need to contact them if we don't already have that consent on record with them. And one of the things to be note about the consent and why I said it's specific, is really important to know the specific rules. Because here, even at the institution, if a student signs a consent for us to disclose to the parent, that consent is only valid for 180 days. The student has to re-sign it for it to continue to be active while they're a student here. And so sometimes parents are like, oh, they signed it. Yes, ma'am, but it expired. They have to sign it again. But I also have to share that you can tell your student to sign it, and they can come back the next day after you've left, and they can withdraw that consent. And then I no longer have the authority to disclose any information to you. And so that's always something that parents, are kind of a little taken aback by. What do you mean that they Yes,
Mhm.
ma'am, they can. So there are different ways in which that consent can actually be given, but also withdrawn.
Wow, that I did not know about. So is it just any day after they signed it, or does it have to be in a specific time frame, or is it, any of those 180 days they can come back at any point and say, hey, no more, no
At
longer.
any point, they can come back and withdraw their consent.
That's crazy. I did not know that either. That is, wow, very, very flexible with the students. That is amazing.
Because
Um,
we serve the students, and that's why it's important to really know the rules of your specific institution.
yeah, definitely. Wow, that's really, really cool. Um, well, you know what? I think we hit a lot of the points today, and this was a wonderful talk. I mean, very, very thorough discussion that we had, and I really appreciate you coming out and talking to me. Is there anything else you would like to include?
No, I will answer any other question though. I appreciate the opportunity because I do think that it's important for students to understand their rights. One of the things that I make sure my team is aware of, and that we make sure the students and parents know, that we are teaching too here in college health. We are teaching students how to engage with the healthcare organizations once they leave here. So we try to make sure they understand as many of the basic tenets here while they're receiving care from us that will carry forward with them. So understanding your rights to privacy and confidentiality applies not only here, but once you leave the college campuses. So we try to make sure they understand the basic principles, but also know that there are exceptions, but know more than anything that it's their responsibility to be informed.
Yeah,
That's the biggest factor there.
definitely. I think you guys are providing such a good foundation of this kind of aspect of life, of your confidentiality. I mean, you're being very flexible with the students. I didn't know 90% of the information that you just told me, and I'm in my junior year of
Mhm.
college. So that is wonderful. I can't believe I mean the thing about the consent, being able to take that back, I mean that's great because sometimes they don't know what they're doing. So, I mean, you're young and this is the stage where you're kind of figuring out what should I be giving consent to and what does this mean? And I think you guys are doing just such a good job at allowing students to make mistakes and
Mhm.
will help you through it, and it's setting them up for the future just excellently. I really, really appreciate the things that you do.
Thank you.
All right, well, if that's all for today, I'm Hailey Hough, and I look forward to seeing you on the next episode of FAQ. Thank you.